Students, today we can go to the one more problem, that is a problem on assault. And with regard to the what is meant by assault, that means an assault is the unlawful laying of the hands on another, and it is an attempt to do a corporal hurt to another, coupled with the present ability and intention. So, in order to constitute the assault, there should be three essential elements should be present. One is apprehension of harm, second one is intention to use force, and third one is capacity to use force. And apart from assault, with regard to the principles of the personal security and trespass to person, we have to see not only assault, we have to discuss the assault and battery and the false imprisonment. So these three elements will be called as it is against to the trespass to person. That means every person has the right to life and his personal liberty. Sometimes this right is going to be infringed. So this is the brief discussion with regard to the assault. Here in examination with regard to the law of torts, this problem was invariably it will be given in law examination. This problem will be invariably it will be given. This problem is similar to that of Stephen versus Meyers, and here this problem will be given in the exams. Here the problem seems to be very much simple, and what the students they will do, they don't know the steps how to solve the problem. So they used to write the problem in the general way, and here what is required is that they have to simplify the facts, they have to frame the issue, they have to write the provision of law, they have to analyze it, then you have to write the conclusion. Here certain times these facts are not necessary. If you just go by issue, rule, analysis, conclusion, it's enough. So this that means without facts there are other methods are there, IRAC, ILAC, that means so many other methods are there with regard to the problem solving. So these methods are called as internationally accepted pattern of the method of problem solving. So here with regard to this problem on assault, let us see what is how to solve this one. Here A was a chairman at a parish meeting. B, who was sitting 7 places, was passed. B was annoyed by this, said that he would rather pull A out of the chair. Then he be ejected and moved towards the A with the clenched fist, but he was stopped by the church warden sitting next. Whether B has committed any wrong, decide. So this is the problem we can see in this the problem. Here what has been given here, here the plaintiff was a chairman of the parish meeting who sat the head of the table, and at which the table the defendant, the member of parish meeting, also sat, and there being the plaintiff being the chairman of the meeting, he has passed the resolution to make the defendant to evict him out of the meeting. The defendant got angry, and he has said that he would rather pull the chairman out of the chair, then he will know the lesson. So he was moving towards the chairman, and it was prevented by the other person. Whether the defendant is liable to pay compensation to the plaintiff for assault. So here they are not given the what is whether assault or battery or anything. So just they have given the problem, the instant problem they have given. So it's normally it has been given in the Karnataka State Law University exams. This problem used to be given normally in the Karnataka State Law University exams with regard to the problem on assault. So here, as I have told you, I used to keep on telling that you have to simplify the facts. Here I have simplified that plaintiff was the chairman of the meeting. Plaintiff asked defendant to go out of the meeting. Defendant got furiated and advancing towards plaintiff with a fit of anger to hit him or to pull out the chair, to hit him or pull him out of the chair. That is in that aspect he was moving towards the chairman. That is that we can see. That means how if he has made all the gestures with regard to the putting the chairman under the chairman out of the chair. So being come acrossing the danger, the other members present at the meeting, they prevented the defendant from hitting the plaintiff or from removing the chair. So these are all the facts of the instant problem. So we have simplified the facts and then we have to go for the issue. That is what is the issue between the plaintiff and the defendant. Here the exact issue between the defendant and the plaintiff, whether this will become the tortious act of assault, whether this will fall under the tort of assault, and whether the defendant could be held liable for the assault. So that is the issue. That means as I keep on telling in all my this problem solving videos, that means the importance of the issue, how far the issue is important with regard to the while you are practicing as an advocate and while arguing in the moot courts or mock courts. And I used to tell you with regard to the importance of this issue. So when the courts when they frame the issues only, they couldn't be able to forward with regard to the trial or with regard to the particular evidence. So here here what we can see here with regard to the issue, this will be under the civil cases, and here the issue has been framed in this way, and we have to look into the provision of law. So here what are all the provisions will be applicable. Here the provisions are applicable here is the essentials of the assault got attracted in this problem. So which are all the essentials of the assault? That is first one is intention to use force, apprehending the plaintiff from being causing imminent danger, and capacity to use force. So these are all the three things we can see in this problem. So the facts of this instant case law, the facts of this instant problem, the facts of instant problem, we can see in the case law of we can see in the case law of the facts of instant problem is similar to that of case law of Stephen versus Mayers. That means here this is similar to that of the case law of Stephen versus Mayers. That's already I was telling you with regard to this case law, and here and I was telling you that means here in your exams with regard to the problem solving, they used to give already decided cases. That means normally the case laws whichever of the problems will be given in the, especially with regard to law of torts, that is with regard to the decided case laws. Here which is the rule of law, which is the provision of law is applicable here, is that here the essentials of the assault will be attracted here. That means the assault provisions will be attracted here, and here we can see the facts of the instant problem is similar to that of the Stephen versus Mayers. Here we can see the same problems of the Stephen, same facts of the Stephen versus Mace were of the similar to this instant problem. Next one, we have to, after provision of law, we have to go for analysis. Under analysis, we have to discuss facts, issue, and the provision of law. So thereby, in analysis, I have not written all those things, but just I have discussed with regard to the gist with regard to the facts, rule of law, and the issue. Here, what we can see here is that the defendant was advancing with an intention to strike the plaintiff, and if he had not been stopped by others, he would have been definitely successful in fulfilling his intention. Fulfilling his intention. So this is the thing we can see in the present the problem. So for this instant problem satisfies all the essentials of the assault. So when the problem, when this case, when this the problem which we can see in this instant problem, when it satisfies all the essentials of the assault, then what should be the conclusion? The conclusion should be that the defendant is liable to pay the damages to plaintiff. So here we have to discuss the essential elements of assault and decided case laws and the aspects concerning to the assault, because here, even though assault is an intentional tort, here we have to express those things. We have to prove that one with our answers. For this one, we should know the law with regard to the what is the provision of law with regard to the any given problem. Then only we could be able to answer the problem and solve the problem effectively. So here the plaintiff has to prove that the defendant has intentionally he was moving towards him, and he can, if he proves that the essentials of the tort, he can get the remedies under the concept of tort. That means here the plaintiff is he can claim the damages from the defendant for the tort of assault.